everyone, and welcome. So we're diving into something huge today. Let's say you think the government's passed a law that's just plain unfair, and you want to fight it. How do you actually do that? Well, here's the thing. It's not as simple as just waltzing into court. There's this whole series of legal hurdles you've got to clear. We're going to call it the Constitutional Gauntlet. So you ready to run it? Let's find out how it works.
I mean, just imagine it for a second. A new law gets passed that targets your business, or maybe it clamps down on your right to protest. What do? Where do you even start? It's a journey, for sure, one that puts both the law and you to the test. Let's walk through those first critical steps together. Okay, so before you even get a chance to make your big argument about why a law is unconstitutional, you first have to prove that you even belong in the courtroom. This is a massive concept in law called standing. Honestly, the best way to think of it is like your ticket to the show. And if you don't have that ticket, you're not getting in. Simple as that. Now, let's be clear. Standing has nothing to do with whether your argument is good or bad, or whether you're going to win or lose. It is all about one thing. Do you have a real personal stake in this fight? See, you can't sue the government just because you don't like a law on principle. It has to have hit you personally in some way. So how do you prove you've got that personal stake? You've got to clear 3 hurdles. First, you have to show you've suffered a real injury. Second, you got to draw a straight line from that injury back to the government's action. And third, you have to show the court that, hey, if you win, the court can actually fix the problem. When you really break it down, it's a chain of logic. The injury can't just be a vague feeling that something's wrong. It has to be concrete, something specific to you. Then you connect the dots. You show that the government's action directly caused your harm. And finally, you got to convince the judge that a ruling in your favor will actually make things right. You have to build that case piece by piece. Okay, so you did it. You cleared the standing hurdle. You're in the door. Now the main event begins, taking on the law itself. And we're going to start with one of the biggest, most fundamental rights we have, freedom of speech. Congress shall make no law. Wow, I mean, that sounds completely absolute, doesn't it? But here's the twist. It's not a total free-for-all. The government actually can regulate speech in some situations. The real question, the one that matters to the courts, is how they do it. So, the very first question a court is going to ask is this. What is the government actually regulating here? Are they going after the message itself, the topic? That's what we call a content-based regulation. Or are they just regulating the logistics, the time, place, or manner of the speech? You know, like a rule against using bullhorns in a residential neighborhood at 3 a.m. That's content neutral. And let me tell you, that distinction is everything. Because if a law targets the content of what you're saying, the government has a much, much steeper mountain to climb to prove that law is constitutional. Courts are and should be incredibly suspicious of any law that tries to pick and choose which messages get heard and which ones don't. But what if the law isn't about what you say, but it treats you differently than it treats someone else? Well, that brings us to our next major challenge, the Equal Protection Clause. This is all about fairness. It asks a simple question. Does the government have a good enough reason for treating different groups of people differently? The whole idea of the Equal Protection Clause is to stop the government from making up different rules for different people without a legitimate reason. But what exactly counts as a good reason? To figure that out, courts have developed this really fascinating system with what you could call different difficulty levels for the government to meet. Seriously? Think of it like the difficulty settings on a video game. If a law gets reviewed under rational basis, the government's playing on easy mode. It's a low bar. But if a law triggers strict scrutiny, oh man, the government is playing on the absolute hardest difficulty setting. And almost always, it loses. So here's how it all works. If a law creates a classification based on race or national origin, or if it infringes on a fundamental right, bam, it triggers strict scrutiny, the highest bar possible. If a law treats people differently based on gender, that gets intermediate scrutiny. And pretty much all other laws, like most economic or social regulations, they only need to clear that low hurdle of rational basis. And this isn't just dry legal theory, by the way. This framework became the powerful engine behind the modern civil rights movement, giving lawyers the tools they needed to dismantle segregation. Okay, let's switch gears a bit to a totally different kind of right. What happens when the government does something that affects your property? The Fifth Amendment has something to say about this. It's called the Takings Clause, and it basically says the government can't just take your private property for public use without paying you for it. But this is where it gets really tricky. I mean, it's pretty easy to see a taking when the government sends in the bulldozers to build a highway through your living room. But What if they don't touch your land? What if they just pass a new environmental regulation that says you can't build anything on the land you own? They haven't physically taken it, but have they effectively taken all its value? This is the central puzzle of what lawyers call a regulatory taking.
So you've basically got two main types. A per se taking is the obvious one. The government physically invades your property, or a new rule just wipes out all of its economic value. But the much more complicated one is the partial or regulatory taking. In those cases, the court has to decide if a regulation has simply gone too far, and to do that, it uses a balancing test.
So what goes into this balancing act? Well, a court's going to weigh a few things. How bad is the economic hit to the owner? Did this new rule completely mess up the owner's reasonable, long-term plans for the property? And what's the nature of the government's action? What are they trying to achieve? There's no magic formula here. The court just weighs these factors. It's this flexibility that lets courts apply these old principles to really modern problems, like new environmental rules that might limit what you can build on your land. So after all that, what's the big picture here? From standing to free speech to equal protection to property rights, all of these complicated legal tests are really about one thing: finding the right balance between individual liberty and the government's need to govern and maintain order. If you remember just one number from all of this, make it 3. Remember, the 3 hurdles you need to clear for standing, the 3 levels of scrutiny for equal protection. This tiered approach, these sets of 3, this is how our courts try to navigate that constant tension between your rights and the government's power.
All right, so let's do a quick recap of the whole gauntlet. What do we learn? First, you can't even get in the game without standing. You need that injury, that causation, and that redressability. Second, if the government targets the content of your speech or makes laws based on race, it's going to face the absolute toughest test, strict scrutiny. Third, for most general laws, the government has a way easier time thanks to the rational basis test. And finally, remember that this whole system, all these tests, are really just a framework for asking one fundamental question: has the government gone too far? And that kind of leaves us with one last big question to think about. These legal frameworks we've been talking about, some of them are centuries old. And now we're trying to apply them to things like online speech, artificial intelligence, and all sorts of complex modern issues. So, are they still the right tools for the job? Are they still the best way to balance liberty and order in the 21st century? It's definitely something to chew on. Thanks for joining me for this one.